All right, can I ask that we gather for our next session? All right, we're going to go ahead and get started. I'd like to introduce you to Chris Schofield and Lisa Scanlon. They're from our SSM Health Legal Division, and they are going to share some valuable information on how to navigate patient care and do it in a way that will be most beneficial for you and the patient. So if we can quiet ourselves, and thank you. All right, Chris and Lisa, take it away.
Thanks, Missy. Quick introduction. My name is Chris Schofield, Assistant General Counsel in-house at SSM Healthcare. I've been with SSM for a little over 5 years at this point. My entire career as an attorney has been spent in the healthcare space, working with large healthcare systems, working with academic medical centers, resident programs. I do a lot of medical staff credentialing issues. I also have a background in risk management, claims management. The SSM legal department has a team of about 25, 30 attorneys and support staff spread across our 4 regions. So Wisconsin, Illinois, Missouri, and Oklahoma. I work on the regional team that helps support Missouri and Illinois. Yes. Can't hear me? Okay, so a little closer to the microphone. Okay. So just saying, I support the Missouri and Illinois regions and entities, including SLU Care and obviously the residency program. On the team that supports the residents, there's a couple of other local attorneys that hopefully you never interact with, right? Usually it's a bad day if you end up having to talk to an attorney. And then Lisa here, she's with the claims team, has been with SSM for what, 4 months now?
So I'm Lisa Scanlon. I'm a senior claims specialist. As Chris indicated, I only recently joined SSM. Before joining SSM, I worked at a private local law firm doing insurance defense for over 20 years. I am one of 5 on the claims team. The other team members each have decades of experience working at SSM and in claims management. Our manager is Kelly Kenline. So with their experience, to say they've seen it all is certainly an understatement, but they are also very experienced and knowledgeable in their positions.
Thanks, Lisa. So this morning, the idea is that we're going to give you kind of a quick flyby survey of a handful of issues that can implicate sort of medical legal risk, and to just help you issue spot as you start your careers as residents here with SLU Care. It's not going to be in depth in any one of the content areas because that would be its own days-long presentation unto itself. So the first thing to talk to you about is that for insurance purposes, medical malpractice, professional liability, your professional liability coverage is provided through SSM. SSM has, it's called a self-insured trust. So rather than going through a commercial insurance vehicle, we insure ourselves. And so the idea with self-insurance is that we're able to more adequately manage our risks. We're able to more adequately manage our claims without having to interface with a third-party insurance company. Part of that is coverage is extended to you and you are expected to cooperate with that risk management and claims management system that we've developed and we have in place. So part of that, and we're going to talk about this a little bit this morning, is if you identify any potential adverse events, then you're expected to report those. And we'll talk about what that reporting looks like. You're also expected to cooperate with our legal counsel and our patient safety teams and our risk management teams. So cooperation is a key component with that self-insured trust to make sure that, one, we're protecting our patients, but also we're protecting your licenses and your medical legal risk and professional liability risk exposure. The caveat to that is that any work you do outside the scope of your program, so if you decide, you get to a point where you're moonlighting, that moonlighting wouldn't be covered by the SSM trust. So at that point, you'd have to see about getting your own policy or see if whatever institution you'd be working for on a moonlighting basis has coverage available for you. So just know, as long as you're doing work on behalf of SSM and or SLU Care, then you're covered. If you go outside that, then coverage determination might not be positive for you. Lisa, anything to add on that insurance piece?
I would just say, as Chris mentioned, we are a critical part to your team. We are here to help. As I mentioned, my team members have a invaluable number of years of experience and knowledge, and to say they've seen it all is certainly an understatement. We are here to help you and to mitigate any potential exposure.
Thanks. Something to keep in mind is that at some point in your careers as physicians, you're going to experience errors. Errors happen. The 98 report to error is human, right? What you need to be cognizant of is, what events led up to that error and how do we handle the error after it occurs? There's times where even if you deliver the best care possible, you practiced within sort of your scope of experience, training, education, everything you've seen, a mistake can still happen. An adverse outcome can still happen. And when you work through those adverse events, when you work through an error, it's important to understand that there's certain aspects of everything you've done up to that point that can mitigate the extent to which you have any sort of medical legal risk, and the extent to which you essentially have a solid foundation for the record that we're going to be able to look at. A key component of that is our event reporting system. So if you ever work at other institutions, every major healthcare system at this point has some database, some event reporting database. At SSM, it's Risk Connect. And the idea with the Risk Connect database is we want to make it as simple and straightforward as possible for anyone who experiences an adverse event, witnesses an adverse event, to be able to report that. The idea is proactive event notification is going to help reduce reoccurrence. So SSM has robust patient safety and quality improvement processes in place. But as part of that, we need good data to come into that system so that then we can act on it. And the more we have that data, and the more we can quickly act on patient safety events, the more we're able to really drive improvements to quality of care. And that decreases the overall risk profile of the institution. I've worked with institutions before SSM and, my work with SSM, where the more robust patient safety and adverse event reporting systems and processes are put in place, it helps decrease the organization's overall medical legal risk and professional liability posture on a long-term basis. And the more we can drive patient safety, the more we can drive improvements to quality of care, that decreases our overall risk of litigation. And when our risk of litigation is decreased, your risk of litigation is decreased, right? So one of the key differences, and we'll talk about this a little bit this morning, is if litigation ensues on a professional liability basis, the hospital gets named, your employer might get named, but you get named too. And it's your license that's on the line. And we want to protect that. We want to do everything we can possibly to proactively protect that and decrease your litigation risk. I'm not going to go into a lot of the specifics on how to event report, how to report events. In the auditorium here this morning with everything else you have going on, it's a little bit esoteric. But at some point, you'll have enough support around you that if you see something, if an event happens, something adverse happens, make sure you reach out at that point in time. Say, all right, I think I saw a patient fall, or I think I gave the wrong medication, or I almost gave the wrong medication. It's important. It's just as important to report near misses as is actual events. One example I like to use is, Pyxis machines over the years, have had a a bit of a design flaw where, yeah, you punch in the first 3 letters of a pharmaceutical and the drawer pops open and it relies on a human to pick that vial out. And Verconium and Versed, 2 different medications with vastly different dosages, right? In Tennessee, a nurse was found to be sort of criminally liable because of the nature and the degree to which mistakes were made. I worked with another system years ago before the Tennessee case happened. They experienced the exact same issue, but they caught it as a near miss. There was a nurse that pulled it, and then during the checks and the timeouts, they realized, oh my God, I pulled the wrong medication. We were able to act on that as a system and change the process and the workflow around the way the Pyxis machines were being stocked. And what happened in Tennessee could have very well happened at the system I was working with at the time. But because of that near miss event report, we were able to save lives. So it's not just the things that actually happen, it's things that could happen and could reach a patient. When we look at some examples, talk about medication errors, medication near misses. If you get a laboratory result on the wrong patient, visitor or patient falls get reported into the system. If there's a delay in treatment or care, you want to report that. And again, with a delay in treatment or care, that might not actually affect any individual patient's outcomes, but it's possible that there are systems and processes in place that led to that delay in care that could affect somebody's outcomes. And the idea is if we can get those event reports into the system, act on them, then we can be proactive in our ability to mitigate all of our medical legal risks. Lisa, have you seen anything in the space yet while you've been here?
Well, I was going to basically give the same, similar example of the medications. I think we all know a lot of medications, the pills themselves can look similar. And what we're looking for in these near misses and event reports are patterns. And if we see patterns developing, we are able to either perform education or create a new process to try to avoid that potential adverse effect. And as Chris mentioned, patient falls and visitor falls. It could be a family member coming to visit a patient. If you see one of them fall, it's just as important to report that as it is if your patient falls themselves. We see falls a lot, unfortunately. And I heard somebody say that people don't expect patients to fall in a hospital. We are there to care for them and protect them, but it's a fact of life. People get up, maybe a bed alarm isn't working. If we see a pattern, we can check the equipment and make sure that everything is working as it should. So it is important to report everything. If you're unsure, it's better to report it so that we can look for those patterns and avoid repeat injuries.
Yeah, one of my favorite, quote unquote, favorite events that happened in the patient fall space years ago. I was working with a team that there was a nurse in the OR that wasn't sure if what happened should be considered a patient fall or not. There was an issue of transferring the patient from one bed to another, and there's a slip up, and the patient ended up on the floor. I'm talking to the folks in the OR, like, well, it wasn't a fall. We caught them on the way down and slowed their descent down to the ground. It's like, well, all you're talking about is a degree of acceleration in that fall. Just because you were able to slowly, gently place them on the ground as gravity was taking hold doesn't change whether or not we consider it a fall. Now, we might do an investigation and come to the determination it's not a fall. Let us know what happened, though, because if it was an equipment failure, one of the beds, if it was a process error, maybe we didn't have enough people in the room to help transfer the patient from one bed to another, then we don't know what we don't know at that point. Let us know if something happened that wasn't supposed to happen. And patient was not supposed to be on the floor that day, right? Not part of a sterile procedure. So that's one of those things that, from an event reporting perspective, it's not necessarily the expectation of the reporter to call those balls and strikes. Let us know what happened. Let the system know what happened. And then there are systems and processes and teams and departments that take over And they do the analysis, they figure out what could have gone better, they figure out what process improvements can be made. Or they realize it's just maybe someone, chalk it up to an actual genuine mistake that can be trained and coached on at that point. Important to know that when an event does happen, we are very much patient-centric, patient first. So make sure that in any circumstances, if an event occurs, the first priority is absolutely to take care of the patient, and then make sure that nobody else is at risk sort of associated with that. From there, that's when you think, all right, I've taken care of the patient. My next steps, what are those? I'm going to report to the attending. I'm going to let somebody else know that this happened. Part of SSM and SLU care, I'm sure you're going to hear it at some point over the next few days if you haven't already, is that, we have a just culture environment. We're looking for system and process failures. We're not necessarily looking for human errors because we know human errors happen. And so transparency and accountability is what we're going for with just culture. And then we document what happens, right? So we want to make sure that we're documenting objective facts in the medical record. If the patient descended to the floor, chart that, right? From there, we're going to look at, all right, is a disclosure to the patient and their family necessary and appropriate? And I know you've had a session on disclosure already. And we're going to talk about more facets of the disclosure process here in a little while. And then, while it's still fresh in your mind, you want to make sure that you submit that event report to the extent that you feel you're the one that's going to be responsible for doing so. To highlight again, event reporting is this proactive process. It allows us to get in front of these system and process errors that lead to medical errors that may or may not result in harm. One of the things I think is interesting when lawyers give these sort of presentations is there's a tendency to say, all right, these are absolute worst case scenarios. When I look at an event reporting system, a system of SSM size, over the course of a year, we will have tens of thousands of event reports entered into the Risk Connect database. Out of those tens of thousands of events, the majority of them have no patient harm involved whatsoever, but can still lead to meaningful patient safety and quality improvements. Events that do have some component of patient harm, maybe because it's a known outcome, a known complication that we have to maybe look to manage, but doesn't necessarily result in any sort of legal professional liability claim. A subset of those will result in someone making an attempt to assert a claim against the institution. And an even smaller subset of those result in litigation. So, the entire event reporting process from an attorney's perspective has this funneling effect where we focus on the absolute worst events that occur, but the system from a safety and quality perspective and a clinical risk management perspective necessarily has to look at the entire world of events. When you're documenting in the medical record, so this is a little bit different. So when we talk about event reporting, we want to know the facts of what happened. And during the event reporting process and investigation process, we'll be able to elicit opinions, what your thoughts are. But that event report, that the fact that an event occurred likely also ends up in the medical record in some component. So that patient fall, it should be documented that the patient descended to the ground, right? Now, you don't have to include all of the details in the medical record. You still want to make sure it's limited to just the facts of what happened, devoid of any opinion or color commentary. But the idea is that it helps complete a factual and accurate portrayal of what care this patient received. And the other thing that I like to talk about is you don't want to criticize others in the medical record. I've seen situations where physicians start sniping at each other sort of passive aggressively in a patient's medical record, where, if Dr. Scanlon had showed up 15 minutes earlier when I called her the third time, then maybe this wouldn't have happened. That's not the right forum for that sort of color commentary, right? And that sort of color commentary in the record ends up creating more questions and more problems down the line, especially with HIPAA and interoperability and patients' right of access, where that charting, as soon as it's signed off on an Epic, is in a patient's MyChart, and you may still be interacting with them. Like, well, why didn't Dr. Scanlon show up when you called her? Not necessarily pertinent to the care being provided at the time. And you also want to make sure that you avoid using sort of flowery or inflammatory language. It's really, should be a very dry read of the medical record, right, Lisa?
I agree. And to the point, I'm sure Chris is going to mention this, that medical record, and he did, but just to reiterate, the medical record is fully discoverable. Not only can your patient read everything that you've put into Epic in that medical record, should they assert a claim or file a lawsuit, their lawyer gets it. So anything you put in there is discoverable. And that's why it's important to only include the facts and be objective and not point the finger or criticize any of your colleagues. That is definitely not the forum.
Yeah, and I mentioned, sort of the passive aggressive sniping that occasionally occurs in the medical record. I also want to recommend don't highlight if you speak with risk management or legal. You don't include that in the medical record. We're not part of a clinical decision-making process, right? I had a conversation with a physician a few months ago, and at the end of the conversation, it was some sort of tricky issues around informed consent and patient representatives and some end-of-life decision-making issues. And at the end of the conversation, he asked, all right, thanks, Chris, that was informative. Should I go ahead and document this conversation in the medical record? Absolutely not. Because nothing raises a patient or their family's sort of alarm bells faster than saying, well, I've reached out to legal or I've reached out to risk management. If legal or risk management gets involved in a case, we want to have that control over first point of contact. Also, if it's a situation that leads to litigation down the line, a plaintiff's attorney sees that, oh, you called an attorney while you are providing care, there's a problem there. There may not be, but it doesn't look great in the record. And again, a consult with risk, a consult with legal, not really pertinent to the care that's being provided. All right, now with disclosure, I understand you guys had an entire session on disclosure. So I want to really focus, for my purposes, the medical legal intersection of the disclosure process. So, if a disclosure needs to take place, you're informing your attending, business manager, risk management, VPMA, CMO. There's a whole team of people that can support the process. That during a disclosure conversation, you want to make sure you're relaying factual information. It's timely so that patients and their families understand what's going on. In most states, including Missouri, have essentially, they're called apology statutes, where a physician is able to make an apology in the moment and not have those words used against them later on if litigation ensues. Part of the reason why, from a medical legal perspective, this disclosure process is so vital. It is one of the largest tools you have to mitigate your medical legal risk. When a mistake happens, when an event happens, when you're communicating with the patient and their family, then that accountability, that transparency, even in a tough situation, feels good to the family. The research out of University of Michigan, they've developed the Candor program, out of Stanford that developed the Pearl program. The disclosure process was shown time and time again to be one of the biggest influencing factors on whether somebody walked away from that episode of care and felt as though they needed to pursue some sort of claim or litigation. You know, it's possible for something bad to happen to someone and then to understand and accept that without needing to escalate.
I was going to say, I think all of you, everyone is familiar with the term bedside manner. To go along with SSM's mission, it's important to show empathy, to let the patient and the patient's family feel seen and heard and be transparent. We all know you're extremely busy, you're tired, you see a lot of patients, and you may know that absolutely nothing went wrong, but to that patient in that moment, it's the worst news of their life. So sit down, have a short conversation, be present in that moment, and let that patient feel heard, and tell them what happened honestly and openly from an objective medical standpoint. And it could just be the difference between that patient reaching out to an attorney. You never know.
Yeah, you know, one of the things that, you know, we talk about with a fair degree of frequency sort of in our world is you can have a physician who is absolutely the best clinician you could hope for, but complications occur, mistakes occur. I don't care if you're the best physician, if your communication skills are subpar, then it doesn't necessarily matter to the individual who experienced that adverse outcome, that complication. Even if you fully disclose that the potential for that complication to the patient, the way you handle the communication can directly impact whether or not they walk away and think they're hiding something. My only recourse is to hire an attorney and drag it out of them. On the flip side, I've worked with plenty of physicians that will openly admit, I'm okay. You know, I'm not the best clinician. Some of my peers are, you know, significantly better than I am, but the patients of these physicians, if they love them, you know, they can make mistake after mistake after mistake, error after error after error, and never get sued, never have that claim levied against them because they've found that sort of sweet spot where, you know, they understand how to interact with patients. And that ends up being a significant tool in their bag to make sure that their professional liability risk is mitigated. Again, I'm not going to go over all of these tips because the through line is really take the information you've learned from your other sessions and just the disclosure process and understand that as you work through each of these components, as you become adept at each of these talking points, that you're progressively decreasing that medical legal risk, that potential for professional liability. And then back to documentation on the disclosure process. You know, it is absolutely something you want to document because if it does go south and turn into litigation, the litigation process is going to drag on for years, and in the pediatric space for many years. You know, if you end up going that route. And the documentation, what you talked about in the disclosure, what the patients knew at the time, how that impacted the patient's decision-making process. You know, if it's not in the record in 3 years when we're looking at it, then we have no way to source that information again. With the disclosure process, and the reason why it's so important from a medical legal risk mitigation perspective is it helps people understand what happened, what went wrong. And that's usually all families and their patients are looking for. Why did this happen? What happened? Is there anything that could have been done differently? You know, how are we going to make future decisions? What future questions do we need to ask from healthcare providers as we're going, as we're, you know, continue to be patients? You know, being able to express that empathy for the patient, for what the patient and their family is going through, after an adverse event. It helps the patient and their family sort of navigate a potentially traumatic event, which again, if they feel as though, if the patient feels as though they've been heard, the family understands that mistakes happen and you're still trying to provide the best care possible, then it decreases that motivation to hire a plaintiff's attorney to try and get additional information out of the organization. Yeah, and this is something that's been proven time and time again, sort of as medical malpractice litigation has evolved over the last 20, 30, 40 years. You know, the historic risk management approach was circle the wagons. A mistake happened. Oh my God, we can't let anybody know what happened. We have to protect the record. We have to protect the institution. And that left patients and their families no other option but to seek it out in discovery and litigation. Whereas if you're upfront, you have that disclosure conversation, you let them know what happened, why it happened, what we know about what happened, and even steps that we're looking at taking to the extent we know those, so it doesn't happen again. More often than not, again, that helps mitigate the risk and decreases that motivation, that incentivization to try and drag something else out of the organization. Handful of areas here for, you know, sort of higher risk for errors. Incidental findings is a big one year over year, where you get test results and you're focused on what you sent the test out for, but maybe there's some incidental findings that also need to be disclosed. Follow-up care. And this is challenging. And this is actually a frustration point for a lot of physicians where, you recommend follow-up care. You recommend, maybe you need outpatient therapy. Maybe you need to get some additional diagnostic work done. Maybe you need to go to the pharmacy and pick up your medication. You have no control over whether your patient actually does any of those things after the visit, after the discharge. However, if the patient doesn't do something, they may still have an adverse outcome and they may still try to hold you accountable. Lisa, have you seen that?
We have, and I was going to say, be clear in the record, be concise. Record keeping is a key factor in mitigating any lawsuit or litigation. And with your discharge instructions, just remember, you might be, what is routine to you as doctors, as a surgeon, is not routine to your patient. They may have just gotten the worst news of their life. They may be sitting there in a fog, nodding their head saying yes, but are they actually understanding? Clearly document your follow-up instruction, indicate whether the patient verbalized understanding. As Chris mentioned earlier, and it's on one of the slides, if it's not documented, it did not happen. I have a case in Oklahoma where there's question on the discharge instruction after an ED visit. And the discharge record is not clear on that instruction, and that's a problem for us. So it's important to document, and again, clearly communicate with your patient, indicate that they verbalized understanding. That documentation could help.
Yeah, one example I like to use in this space that to this day is still one of the ones that I just can't wrap my head around, why someone thought they had a legitimate claim. Patient goes into their primary care provider's office on a Thursday, complaining about some sort of indigestion, a little bit of chest tightness. And, the physician, prescribes whatever he prescribes with very clear instructions. If this gets worse, either come back or go to an emergency department. Friday night, the patient calls into the office's after hours line. Said, this is getting worse. The medication's not working. Oh, sir, I strongly recommend, doctor's office is closed for the week. Recommend strongly that you make it to an emergency department as soon as you can. Sounds like you're having some potential heart issues. Patient chooses not to go to the emergency department until Sunday night. physician staff has no control, has no ability to compel that patient to seek care. Patient has a heart attack, unfortunately passes away, and his family wants to sue the doc for not doing enough. It's like, what else could we have done? And that's why that follow-up care, the fact that we were able to document the conversation that occurred in the office on Thursday, the fact that we had documentation of the nursing hotline call Friday night, we felt really good about that record going into litigation to say, you can't come after us for what an individual chooses not to do, right? Another high-risk area, anytime you're transitioning care, handing off, making sure that the care team has all of the necessary and appropriate information to act on. And this is an area where Epic is a bit of a double-edged sword, because the information is there in the patient's record, provided you've documented for all the necessary information that is required for a care transition. However, there's so much information in Epic that not everybody is going through and reading all of the record all the time during transitions. But just understand, it is an area that we see that increases risk. On to documentation. Again, Lisa said it once already, if it's not documented, it didn't happen. Making sure that the care you're providing is documented. One, it's the best way to communicate what you've done regarding the care you provide to a patient. It's also your best defense against a claim. The more thorough and accurate the documentation is in the health record, the more we're able to evaluate the extent to which a claim has or doesn't have sort of legs. If you don't document it, or if the document is spotty, if most of the documentation looks like all you've done is copied and pasted a bunch of notes day after day, then we don't have much to go off of. Commentary on that, Lisa?
I would also say be careful with using automatic dictation. Again, we all know you're busy. I tried dictation software on Friday because I'm used to dictating from my private firm life. And I quickly realized it's good for simple terms, sort of. It didn't type medical terms that thought was explicit for whatever reason. Go back and proofread what you've entered in the chart. I can't tell you how many times we see someone comes in clearly identifying that they're there for a right knee injury. And one sentence will say, range of motion decreased in the right knee. The very next sentence will say, swelling in the left knee. Okay, well, which knee is it? Proofread your chart, because it is also your best defense. If you have a sloppy chart, which kind of goes with the cutting and pasting, you need to make sure it's accurate. It does not look good. It's a bad appearance. You maybe did not do anything wrong, but if it's a sloppy chart, it does not help the circumstance. And to go back a little bit with the documenting of discharge, and I think on this slide it talks about refusal of care. Mention again, if you have a patient that seems hesitant to follow your instruction, you need to document the instruction, but also document that you discuss the risks of not following that instruction, so that that is also clearly in the record, that they understood or were at least educated on the risks of not doing something from a medical standpoint.
Yeah. And again, with the idea that using dictation can lead to sloppy documentation, copy pasting can lead to sloppy documentation. It's not to say they're not valuable tools, right? But saying that the dictation software didn't adequately capture what you dictated into the system is not a defense. Saying that the dictation software didn't correctly capture what you meant to say is evidence that maybe you don't have as much sort of care to pay that much attention to the patient. There's a physician I worked with on an issue where English was a second language, used dictation a lot, used copy paste a lot, generally a pretty good surgeon. Uh, but he was fast and he never went back and proofread anything. And his documentation ends up being problematic. There's turned into a couple pieces of litigation with sort of a known complication. Documentation wasn't adequate to really defend the care because it was all copy paste and poorly dictated. And by the time we're talking to him, he doesn't remember the specific patient. A year passes, 2 years pass. He's seen so many people between then and now. Whatever's in the record is what we have to go on. Let's see here. You want to make sure that what you document is specific to the patient. Any discussions with patient family, your thought processes, if there's refusal of care. But again, as you're documenting each of these sort of categories, you want to make sure you're doing it in sort of value neutral ways. You're doing it in sort of in a dry factual manner without sort of incendiary commentary. If someone's refusing care, that's their right as a patient. They don't need to be called out on it using pejorative terminology in the medical record. One, they're going to see it and complain about it. But two, it decreases the perception of you as the professional. And if you can't document professionally, again, that erodes your ability to be a sound defendant, right? You want to try and stick to the high road there. And then any phone calls, follow-ups, again, the facts of the medical record, or the facts of what happened, what you primarily want to include. Let's see here. Couple of do nots here. So never alter a medical record. So there's ways to edit notes. There's ways to do addendums to notes. We don't have the ability to delete anything out of the medical record. And so you want to make sure that you don't try to sort of circumvent some of the systems that are in place. You also want to try and avoid sort of value added language. Like, you don't necessarily want to include that an error was made or that, just this huge mistake occurred. You're not including that in the medical record because the fact that an error occurred at the time of charting may or may not be accurate. We may be able to conduct an investigation and find out that, it wasn't actually an error that any individual caused. It may have been a system or process failure. It may have been a device failure. It may have been a situation where, there were comorbidities and there was this known complication that maybe wasn't adequately discussed. Referencing as an error is a value judgment. And that's what we don't want to include in the medical record. We want to include that something happened, but leave the sort of analysis to, the debrief afterwards. Talked about earlier, if you've got disagreements between other providers or departments, the medical record is not the place to passively aggressively snipe at each other. Conclusions without support. Yeah. So, including documentation, labeling an individual as a drug seeker, incendiary, that can be incendiary for the patient because they're going to see the record and they're going to say, oh, I'm not a drug seeker. I was in legitimate pain that you ignored. Whereas rather than saying someone is a drug seeker, you can document that, the patient reported certain pain levels, location of the pain, and what your recommendations for care are. You don't necessarily need to include that they were pretty apparently seeking narcotics in this for this data service. Because not only does that sort of inflame the patient who may or may not be a drug seeker, and if they're not, then that can result in a complaint to the Board of Healing Arts or state licensing authority. And then you end up creating more problems downstream from using that sort of incendiary language. And I mentioned this earlier. You don't necessarily want to document that you're speaking with risk management or legal. We're support resources. We're not providing clinical documentation. All right. little bit about the consent process and sort of trying to be cognizant of time. So I'm going to go into a lightning round here pretty soon. With informed consent, it is the responsibility of the provider who is performing the care to obtain consent. Yeah, it's a conversation I have sort of year over year. It's sort of a pretty common issue where, how much of that consent discussion can I delegate to someone else? How much of a consent discussion can I rely on someone else to have for me? I was working with a radonc group years ago, and we were revising some of their consent forms. And they had this line in there that either myself or my partner has explained to you. It's like, how much do you trust your partner? Do you trust they're going to share all of the exact same information in a risk benefits alternatives discussion as you will? Because they're obtaining the consent on your behalf. You're the one performing the work. You're the one that gets named in the lawsuit. And if you're the one that gets named in the lawsuit and one of the allegations is, I didn't know this could happen to me, you have no defense to that because you don't know if your partner explained that adequately or not. You're relying on somebody else's work in an area where you really need to focus on what you do. And with informed consent, you want to make sure they understand the risk, benefits, alternatives. And part of the challenge there is that with any given procedure, there's going to be an entire list of potential risks, entire list of alternatives. And so it turns into a sort of almost an academic discussion around how deeply do I go into each of those risks? How deeply do I go into the benefits that are associated with it or the alternatives? If I have, two different surgical options, wait and see approach, or some other conservative approach, do I have to go into the risk benefits alternatives for each of those? Or do I focus on sort of likely outcomes, likely complications, likely risks that can occur? And that's something that you develop over time to really understand which information for which patient ends up being sort of the most pertinent. If there is a 1 in a million chance a known complication can occur, how much time do you really want to spend on that? Because it's not likely to be pertinent to an individual's decision making. Anytime someone goes under general anesthesia, there's a risk of death. Sure. There's a greater risk that during the intubation process, their tooth would get chipped. I guarantee most people care more about their teeth than whether or not they might die in that context. And so we see a lot of that sort of litigation, that sort of claim assertion in the anesthesia space around chipped teeth, lost teeth. And it's like, I didn't know that could happen. Well, we should have explained it to you because it can.
This is also a great opportunity for you to practice that bedside manner, develop that patient-doctor relationship. Ask them if they have questions. When you've developed and determined which risk factors or complications to discuss, take that extra second, ask if they have questions, answer them, document that their questions were answered. If it ends up in litigation, that patient, assuming they're survived, will be deposed. And if it's in the record that you indicated they asked questions and those questions were answered, our attorneys can ask that patient. It indicates you're claiming you did not give informed consent, but the record indicates that you asked questions and those were answered. So document, give them the opportunity to ask questions and then explain it to them and be sure to document.
I'm not going to specifically cover who can consent. SSM has very extensive policies that address this, and I recommend that you take a look at those at some point over the next couple of months. Subpoenas, summons, deposition. So this is more into legal process, hopefully very, very, very far removed from your personal experience from what we're talking about today. Part of the reason why SSM does have a legal department and a claims management department and a risk management department is to help support our physicians, our staff, anytime a legal document shows up out of the result of work you've performed for us. Yeah, so with a subpoena, it's either requiring you appear for a deposition or a hearing or trial. There's some nuances to that. A summons indicates you've been named in a lawsuit, for residence purposes. I always think it's interesting when a resident gets named in a lawsuit, because we try and get them diverted to who the attending provider was. And as you work through residency, and get more independence, or your risk for making a mistake and the risk for being the primary provider in the record increases somewhat. If you do get a summons, you get a subpoena, your first step shouldn't be to access the medical record to figure out what was going on. It's to flip it over to risk management, flip it over to someone in legal so that we can help you navigate that process. Let's see here. I will say that
I was going to just add, make sure if you are contacted by a lawyer, this is common sense. Plaintiff's attorneys know they cannot reach out to you, but that doesn't mean some may not. If you need to take a step back, if you get a phone call, make sure that it is an SSM attorney reaching out to you before you discuss the case with them. And it's okay to say, can I get back to you? Can you give me your name and number, and check with risk or the legal team and make sure that it is an appropriate contact before you discuss that case.
I want to say, over the course of your career, you have a 75 to 99% chance of being named as a defendant. Yeah, so not quite a certainty, but a near certainty. There's an entire process that takes place when you're working with an organization. You want to make sure that you have appropriate professional liability coverage in place, which, again, the work you're doing for SSM, you absolutely do. I was working with a couple of pediatric endocrinologists years ago. They received a summons. So they've been named in a suit. One of them that I spoke to let him know what was going on, what the process would be. He's like, okay, I've been named in a lawsuit before. It's fine. I'll talk to you in a couple months when you need information from me. The other doc was absolutely beside himself. He had to cancel his afternoon, sort of had to have a bit of a hand-holding session because he's like, is this the end of my career? What do I do from here? How do I go back to patient care? I've been named in a lawsuit. And through that, pointing out that, yes, you've been named in a lawsuit. No, it's not going to end your career. Most every physician gets named at some point. And by the way, you're going to have to live with this up on the shelf for the next couple of years because litigation is slow. The entire timeline for it to unfold, you're going to have to find some way to move on, go back, treat your patients, and then let the legal team, let the legal department and our assigned counsel help you work through this and process from there. And then again, that funneling effect I was talking about, tens of thousands of events, de minimis number of those resulting in claims, a fraction of those resulting in some sort of payment. So just know if you're named in a lawsuit, it can happen. It doesn't necessarily mean you did something wrong. It just means somebody wanted to file a lawsuit. One of the attorneys I work with likes to say anybody with $100 can file a lawsuit. It doesn't mean that lawsuit is legitimate. It doesn't mean that there's actually a cause of action there. And adverse outcomes don't necessarily equal bad care. When we look at when a lawsuit gets filed, the duties that we look for on the legal side: duty, breach, causation, and damages. Duty is pretty well established. You have a duty to provide care within the scope of your experience, training, and education. Breach, that turns into a question that lawyers and juries have to figure out. Was this a known complication, or what did a mistake happen? And did that mistake lead to whatever damages ensued? So if somebody was out of work for a while, if somebody needed revision surgeries, if somebody passed away, did the potential mistake lead to that outcome? And that's what we're looking for in the context of a lawsuit. Again, it's a long process. There's the pleading phase where we're drafting the complaint and responding to it. discovery. So we're trying to, the plaintiffs are trying to get access to medical records. They're going to subpoena individuals to take witness depositions, and then eventually that ends up in resolution. Julie, I believe we're at time, aren't we? So feel free to take a look at the rest of the slides. Thanks for having us. And then if you have any questions, I'll be around.